responses. Mr. Molife, Media, TNA Media, Ben Gubane, Dr. Ben Gubane, the Minister, and the SABC. Those are the last four. You'll also recall that we'd agreed that we will get some sort of briefing around the MOI. The research team have requested, and I hope you accept, that they would want a little bit more time and they'll be ready to give it to us tomorrow because they just need to do some cross-checking. So that one will be done tomorrow. Advocate Vanara, if we reach that point, will then give us the areas where there's been contradictory evidence. And we are going to ask our legal team, Anthea, just to clarify the areas that you recall that there were questions around the technicalities of inputs that we've received so far. So we'd asked Anthea to go and do some work about that and tell us around those matters. So Anthea will tell us those matters. And I've been reliably informed that I could, in brief, summarize Honorable Singh and Waters the content of the letter, because members are saying that we should read it into the record, but you have it, we'll read it, but I'll just summarize what it is that we said in pursuant to what Honorable Swartz had requested earlier this morning. So could I ask to answer the question on the status of inputs that we have considered those so far and other inputs that we will consider immediately after this.
Thank you, Chair. The issue I think that arose this morning was about the standing of the SABC document, as well as the status, considering that during the phase of the inquiry, some witnesses were sworn in, and there's been replies to the interim report by this inquiry. In the main, what we are dealing with now is a process of reply. A legal process has different stages, and at the beginning we would gather evidence, witnesses are sworn in, people give testimony under oath. Obviously we had a few presentations where people were not sworn in because that was accepted by the inquiry to be just presentations to the process. So following the interim reporting, we have received various responses, and what that now is a reply. It's a reply, it's putting people who were before the inquiry in a position to respond to matters that in the main affect them. That is in line with the principles of natural justice. So where we have received responses from witnesses who were before the inquiry, those documents can be seen as an extension of the main evidence, even though they don't need to be sworn in. But it's still part of the inquiry, but it's not evidence gathering. It's really just ensuring the inquiry that they are satisfied with what comes out with the final report. In respect of the SABC's response, we know that the SABC did not place evidence in the main before this inquiry, so their document before the committee should really be centralized and focused on the evidence that came out in the interim report. This morning, members were concerned with the raising of new evidence by the SABC, and unfortunately, the introduction of new evidence finds itself at a very late stage in the inquiry and is therefore not part of the formal process. Nothing stops this inquiry from making recommendations to the extent that there were further evidence identified by SABC which another forum can consider, but for the purpose of this process, it's replies to the interim report. Chairperson, I should also just note that reading these documents over the weekend, I particularly noticed that the response by the Minister and the SABC's reply are marked confidential. You'll see in the footnote in the header rather to the minister's response, it's got a little comment confidential, and the SABC's document has a watermark that states confidential. That marking has no status. When this inquiry started, it was placed on record that all processes will be open and in the public. We had requests as the inquiry when we started for certain witnesses to give evidence in camera and in private, and that was declined. So that was just to alert members that that marking of confidential on those replies indeed cannot be considered as confidential for the purpose of this public process. Thank you, Chair.
Comments, if any? Yes, sir. Followed by Honorable Singh.
I just want to ask, maybe just to go back to the status of the SABC document. I just want to elaborate just a little bit detail on how do we treat this information, as it's information that comes after our observation. How do we deal with that? The fact that the submission is not done under oath, obvious, and therefore, what weight does it carry moving forward with what they are raising? So that we are very clear from the start that when we deal with it, it's information we can rely on. The second thing, again, that I definitely want to, maybe you'll have looked at it, is the mandate, signing off of this document. What mandate, whoever that signs off that document, what would supposed to have been a process, vis-a-vis the fact that the accounting authority, as we know, is non-existent, meaning that the authority that takes decision, in fact, on behalf of SABC, which is the board of SABC. Then we have your administration that deals with the day-to-day running, but the authority lies with the board. In the absence of the board, and when you look at the content of the information that is in the SABC, speaks as far as dealing with issues of the board and the board decisions. So maybe if we can just get clarity on that space, and then so that when we begin to engage with it, all of us are sort of satisfied that it's information that is relevant, it's information that can be tested, it's information that can be defended by anyone. So I think that is very important for me, because you'll know the reason I'm asking these things, that we have given from the start of the process, SABC was the main, in fact, the board, SABC, were invited to an extent that they end up going to court, and they lost at the court. Then they came back, then the process again, every single hearing that took place here, the chair will always call on SABC to comment. And that opportunity was given. I'll take it like that. That opportunity was given, and there was nobody until the last, when the chair then make a closing remark that nonetheless will send the interim report to all stakeholders. So therefore, is that informed by that comment of the chair? What's the status? So if you can just clarify those areas for me, I'll definitely be happy, so that when we move forward, all of us are very clear, because people have gone through hearing here, witnesses, grilling, serious grilling, by the way, you know, to an extent that SABC was not there, right? Now, if we are to bring in this information now, contest information of people who have gone under oath, by the way, contested by people who have not gone under oath, what does it mean? So these are areas that I thought we should sort of look at, and then be very clear that if we take this evidence, what grounds does it have for it to stand before us? Thank you.
Thank you, Chair. And thank you for the legal advice. I'm just trying to follow in. I'm going to follow in the same vein, but before that, I'd just like to know: are we obliged as a committee to respond to the responses that we've received in any form whatsoever, except for an acknowledgement? So, you know, to those that have sent in their responses. First, that's the first thing. Second one is the SABC responses that we received here. Did it come with a covering letter, and who signed the letter and on whose behalf? I misplaced that letter. Well, not misplaced. I might have got it in my office. And we requested them to respond. Now, given that we requested them to respond to the report, aren't we then obliged to consider what they say in response? I'm just playing devil's advocate, because we're hearing from our legal advisor that we should not, even consider what they've said and leave it to another committee or whatever else. But I'm just asking aloud, are we not obliged to consider it because we asked for a response? Thank you.
Chairperson, in similar vein, just clarity. We have all along said that there will be a call for responses from parties that are in fact mentioned, and obviously the SABC has a significant reason to believe that they should be able to respond. But my concern is, if we look at the submission which was made in the name of the company secretary, now, can legal please indicate to us? My understanding was that the company secretary is there to advise the board in terms of the Companies Act, to give guidance and advice to the board. In the absence of the board, obviously the person is not really fulfilling a specific position. Now, can we, therefore, if the SABC has replied on behalf of the executive, would that not have been more appropriate, since we do not have a board at present? Now we have the company secretary that would ordinarily have replied on behalf of the board. But since there is no board, is that the correct person to reply? And would that also have an impact on how we consider the significant submissions made by the SABC? Thank you, Chair.
Honourable Khoza, Honourable Waters, you'll follow.
Chair, I also need some clarity around the status of the response, given the fact that it was, well, my assumption is that Professor Makuve, when he was giving evidence, he was giving it on behalf of SABC. Now, that also goes with the signatory of the letter of the person who has responded. In which capacity does that person respond? Does that person respond on behalf of, including Makuve, because he is the one basically who was the key individual and the company secretary that did give evidence? And if you could clarify those issues, because the issues that they are raising there, they're bringing up issues on motoring and so forth, but in the actual fact, the people that came before the committee was Professor Makuve and the company secretary, and I just need to be clear on that regarding the recent board.
Chair, just on the legality of the board, as far as I understand it, the board hasn't been dissolved. So, so theoretically, there still is actually a board in place, although they can't form a quorum and make any decisions, right? So the question then, there's only 3 members left, and they're all executive members of the board. So my question to the legal advisor is then, on what authority was this legal opinion sought, and also, does the company secretary have the authority to initiate this legal opinion? And if not, then who does, and why haven't they signed the document? Because the company secretary signed the document. So I just need clarity on that, Chair. Thank you.
Chair, thank you. The concern that we raised earlier on, indeed, members have spoken to it. But perhaps the important question that one should ask is, perhaps to get clarity, is when we send the correspondence as the ad hoc, who did we send it to? I think that's an important question. If we send it to the secretary, group company secretary, then perhaps we will then consider the response. If we send it to someone else, the question would be, why did that person therefore send it to anyone else? Perhaps we are just, perhaps perhaps it's only, perhaps that's a question we should have asked in the first place, so that we should not belabor matters which possibly we may have created. But there's going to be some questions, obviously, that we will raise. You'll remember that when we had the presentation, we also raised the issue whether we do have a company secretary. When was the company secretary appointed? Those questions were not properly answered because at the time when the lady who was presenting here presented, she actually did say that there was a lady who was going to be a company secretary. She was leaving the position to becoming a chief risk and whatever you had to view. So I think we must just clear those things. And I think if we did send a secretary to the person who's responding here, we could then perhaps get into the document and look at the issues that are raised, because indeed there are issues that have been raised in a very bad light. But I guess we'll get into that matter when we deal with the content of the document. For me, what is crucial is, who did we send the letter to? If we send it to this person, then it's fine. Let's continue.
Thank you very much. Before you respond, Anthea, let me just remind members not to make a judgment one way or the other, Anthea, that you will do. You will recall that in the old assembly, the SAB stood up at some point and wanted to contribute through their CEO, Aguma. We collectively took a decision that, no, we're not going to afford you that opportunity here and now. You can do it when we send out a report for comment, because you never took the opportunity when it did arise. We took that decision. And indeed, when we sat in this very room after finalizing the report, we sent it out to all stakeholders, including the SABC. When we wrote to the SABC, we wrote to the CEO, Aguma. We wrote to him and said to him, pursuant to our commitment that we will consider what you have to say, here is the interim report. You've got 21 days or 14 days or whatever the date was. So to answer your question, Honorable Mathangu, we addressed it to the CEO because he was the one, and indeed he is a part of the board. He's a part of the board. We've not dissolved that board, though there's no members. I'm saying legally or otherwise. And they responded pursuant to that request that we made to them. So I thought I must give that to Anthea to say, this is the context in which we did it. We requested, they requested, we denied them oral. We said you will do it in writing. Indeed, they have followed the writing. It's before us now. And the company secretary, when she sent it out, it was with the authority, I would imagine, of the CEO and everybody else, because they are CC'd on that letter. Although she put her physical signature at the end of the, and there was a covering letter. Somebody asked the question, was there a covering letter? Indeed, there was a covering letter. And she's been copied, or the CEO has been copied on that letter. So those are the facts before us. No, let me not give my version, because we can debate it later on. But those are the facts before us. I'm just maybe you should respond, Anthea, and then let's have a few minutes debate, because we might have different views on this matter. But we can't be bogged down at the last day. And if you want to respond to them, if you don't, if you need some time, you can do it, because we're not going to get down to it right away. But if you've got initial responses, please do that.
Thank you, Chair. I think I share members' concerns outright. When I picked up the SABC report, the first thing that jumped out to me was the report was not signed. The executive summary and the report in the main, there was no warm body identified to the actual author of the report. However, on the cover it does say Aguma J, the email address. And so, Chairperson, I would think that that is in consequence of the background context that you have just given this committee now, that indeed the CEO, the undertaking from this inquiry is given to the CEO, that the SABC would be able to respond to the interim report. However, I again emphasize that what was required was the response to the interim report, not evidence in the main. And I think there's a substantial difference, because that would speak to Honourable Chauke's concern, that when we have a witness in the main, you'd have the person before the inquiry, all members present would get an opportunity to ask questions, to look at the evidence, and SABC has not presented themselves on that platform. So I think what has happened now is they've given a report that does not only speak to the issues raised in the interim report, but gives further evidence. And so in the respect of the further evidence, that's where my concern lies. And it says, on that basis, this inquiry should perhaps note and say, we note the extra evidence, but it doesn't speak to the issues that were before the committee, that were interrogated. Witnesses came and gave evidence. The committee members had documents and were able to interrogate the process. So that's what I meant when I said just where the report goes beyond what is in the interim, that should just be cautioned against. And then also coming to the issue that members raised on the status of this report. What do we do with it now? It comes under the covering letter of the company secretary. Of course, it would be the company secretary's role to be communicating and acting in the secretariat function. But I think it is important to ascertain who authored the document and whether or not the email address on the cover is in fact an indication that this comes from the CEO. Because if it does come from the CEO, then it should be signed off as from the Chief Executive Officer. From my side, when I read this, I expressed internal caution to the extent that the allegations in the report are very vast and damning and almost dismissive of this inquiry. And my alarm bells went on to say, if I was writing something of this nature, I too wouldn't put my signature to it. So that was just a caution. That was my own observation. And I thought perhaps the committee would want to take that point with the SABC to say, who authored this? Can we get this person to sign this document so that we know with certainty where we stand on the SABC report? But that's just in a brief. I hope I've covered members on the question, but that would be my view, Chair. Thank you.
As a middle ground, honourable members, I mean, this is what we're saying. I'll come to you, Honourable Matlanga. Would it be acceptable if right now we sent an email to the CEO to ask him to confirm that he is the author and or associates himself with the report? Would that be acceptable to members? Because that's the middle ground between everything else that we've done. I'm just asking. So when you respond, please respond to that, because it's not very difficult for us to say, listen, we've got this document, although you haven't signed it, it might be a technicality. Just send us an SMS saying that you associate yourself with the contents, and then we deal with it accordingly. I'm just asking as a middle ground on this matter. And if we can't reach consensus on it, let's deal with the other matters, because it was the last matter anyway on the agenda. Let's take Matlango and we'll come to Chauke.
Well, Chair, I thought we would, under the circumstances, having to deal with the matter, perhaps if it was possible that we have a short closed session amongst ourselves to make an informed decision. I would think that would be the proposal I'm making, but I can be overruled.
No, thank you very much, Chair. I think your proposal, Chair, it's correct that someone must take ownership of this document before us, not only through an SMS, Chair, that confirms or through a letter, someone must sign off the documents. You can't have a document which is evidence before us and is not signed off. Someone must sign it off. Someone must initial page by page, because we don't know what we are dealing with if this thing is somehow contaminated in the process. And the person says, but this is not the document that I gave you. What are we going to do? So let's not do shortcuts. Let's stick to what is law, due process. So we are going to ask SABC to give us their response, formal, signed. That's how we should do it, Chair. If we can make a shortcut, people are currently preparing to take us to court somehow, you may not know. And we are now going to confirm information that is not signed off, and we are using it. In fact, earlier, we're even getting to a point where we're even commenting on information that is put before us by SABC, which is not verified. And I think, Chair, I want to, in fact, further emphasize the point that you make, but to enrich it with saying that we still have to deal with a number of things before we close today's session. Meantime, let them send us their response, which is signed. I will take it that this thing before us does not exist until such time that we receive information that is signed off by someone that will take ownership. We must know the fact that, as I've said earlier, Chair, people have been here under oath, and that had to be respected. When someone just decide, wake up in the morning, send this 2,000 pages to Parliament, and Parliament must just, no one is signing it off. That is part of the problems that we have at SABC. No one wants to take ownership of it. So let someone put his signature here, then we can deal with it, Chair.
I'm seeking wisdom. Is my understanding correct that you are asking us to write a letter to the SABC CEO or acting CEO, asking him to take ownership of this document? If that's what you're asking, we can do that. The second question is, when you say he must take ownership, does he take ownership by writing a responding letter saying, indeed, document dated, whatever it's dated, from page 1 to page 10, I associate myself with that? Would that suffice? I beg your pardon?
Chairperson, and all the annexures submitted.
Yes.
Because in support of the document.
Yes, because the document is, the annexures is in support of the document. Would that suffice, members? So we will send a letter off now, indicating we've got this document. Mr. A, GCEO, please by return mail confirm that you take ownership of this document and its annexures on a letterhead, formally signed by yourself. If that is forthcoming, would it be acceptable for us to go through that document? Is that what members are saying? Because you can't change the goalposts after this. I just want to be very clear, what is it that you are saying? If it does respond in that fashion, would that be acceptable for us to continue with the business of interrogating that report? And of course, like with all other reports, honourable members, if it's new evidence, we're not going to look at it. Like with everything else, we will not look at it. But if it's talking directly to the points from page 1 to page 46 or whatever the page is, it should be permissible. Is that okay? Okay. And would that be okay? So we will send a letter off right now, and hopefully by the time we take a decision on the contents of that report, we would have received a response one way or the other from the acting GCEO formally taking ownership of it. We will send that letter off right now, or as soon as is possible. We'll draft it and we'll send it off. Okay. Is that fair enough? Okay. Thank you very much, members. Then that deals with Anthea's part. Let me deal with the part that you spoke about before we went on lunch. Honourable members, indeed, we, again, by your direction, sent off the letter. So without going through the actual contents, because you have it before you, but just so that everybody understands what we did, we received a letter from Maguva Incorporated, And in essence, the letter asserted that their client, Mr. Motsoeneng, was prejudiced by being denied an opportunity to appear before the committee, and that he would reserve his right. Majavu. No, Majavu, I beg your pardon, Majavu. Majavu Incorporated, I beg your pardon. And basically raising the concerns that their client is prejudiced by our denial of him appearing before the committee, on a formal letter. We responded, and you've got a copy of that response. And in essence, we refute the matters raised in that report on 3 grounds in the main. On the first one, we said that Mr. Motsoeneng is not an employee of the SABC until a disciplinary hearing has been processed. That was the first ground that we raised it on, or we refuted it on. The second point that we refuted it on was on the basis that we afforded the SABC board at the time an opportunity, one, to appear before this committee, and like with anybody else, the right to call witnesses. To testify or to endorse or to corroborate what was said by the SABC board. And the third point that we make is that the evidence or the material in our report is really from evidence that was presented to this committee based on what was tested in the courts and in the public protector's report. So there was a public protector's report that spoke about the appointment or otherwise, and there was a court or 2 court judgments that spoke about the appointment or otherwise. And it was on those bases that we said we refute the allegations. And the final one was that this committee's work is not final. When we've done our business by Friday, we still have to go and present our principal, who is the SABC, who is the National Assembly. And the National Assembly will then be able to apply its mind in terms of whether there was prejudice to anybody or not before it adopts it. So that was the essence of our responses. And by virtue of all members having agreed to it in principle, other than a spelling or a grammatical error on one page, and in fact, the insertion of one word, we were in principle in agreement with it. We've sent it off on that basis with your approval. Now I'm hoping Honorable Chauke and other members that felt that we should put it on the record because it was done publicly, I'm hoping that we've satisfied that condition, because you do have a copy of the letter, honorable members. Is that okay? All right. So we have received, we have responded, and as with all other evidence that would have appeared before this committee, it will be made public once we are done with our business. So both the response and the input will be made public, and people can comment on it, as is with everything else. I'm hoping that closes that chapter of it. Does? Thank you. Can we then go back to what we were doing this morning, and where's our documents? Cindy, you need to help us. I must just check with members. Do you want short input from Letapo on each one, or do you want him to give us a global for Molife, Media, Ngubane, and Motambi? Do you want a short briefing on each one? In essence, we should have read these things ourselves, but I mean, we received that request and we tried to entertain it. But and they are prepared, by the way. They are ready to give short inputs on everyone in terms of the document that we're using as a working document. Let's take Killian. Do we do it collectively or do it individually?
Can we please do it individually, Chairperson? We have read through it, but obviously it just focuses our minds on specifics. Thank you.
Happiness? You ready, sir? All right. Can we then go to Mr. Phil Molife's input on page 18 of the document that we've been working to? And I'm assuming you've got that page, sir? And that is it mine here? I'm sorry if I'm taking your one. No, let me take your one, sorry. That's fine. On page 18, we're talking specifically, Latapo, to paragraphs 1711 to 1715. That is the document that we're looking at. And in your document, I'm not sure what page is it on. On the document that says research, if it's there, you can indicate the page to us. Otherwise, what is before members is 1711 to 1715. And if you could summarize the highlights from that report, and then members can take it from there.
Thank you, Chair. Good afternoon, honorable members. I'll use the research unit document and start with Mr. Molefe on page 14. Mr. Molefe's submission covers 3 themes. The first one is...
Hold on, before you go there. Members got that document? The one that says research unit on the top right-hand corner, right?
Yeah, page 14.
Page 14.
Yep. So, this one. Okay, sure. Okay. The first theme is cost related to the TNA breakfast briefings. The second, the first theme is cost related to the TNA breakfast briefings. The second one is the newspaper subscription contract signed in 2012, and the news channel and trips. And in essence, what Mr. Molefe was saying was that Dr. Ngubane gave the impression that the New Age subscriptions was signed when he was still the group chief executive. He denied that and states that these were in fact the contract was in fact signed by the former CEO, Ms. Lula Mamkobo. He also then gave a breakdown of the costs related to the TNA breakfast briefings, and then he states that SABC bore the cost of the entire production costs, and these costs could go to $1 million or even more depending on the nature of that production. He then gives a cost breakdown which covers the payments for OB, for outside broadcast tax, accommodation for production staff in the event where it's outside Gauteng, and all other costs that relate to that. He then also denies the fact that, because Dr. Ngubane had given, in Dr. Ngubane's testimony, he had given the impression that the trips that Mr. Molefe took were Gupta linked, and he denies that, saying that these were actually study visits which were paid for by the SABC. I then move to TNA. Oh, okay.
Just one at a time.
All right.
Do we want to process that one and then go to the next one? I'm just asking from a process point of view. Yes, sir.
Clarity on the document. The amounts that are showed here on line 5, what is that figure, Chair? Is it 5 million? Or what is it? It's not very clear whether it's a 5 million or it's a half a million.
Which one?
Or it's a misprint.
Oh, it's 500,000.
Do you see the mistake then?
Yeah.
Okay.
This one, yes.
500,000.
Yes. Yeah, so it's 500,000. Yeah.
Honorable Swath?
Very straightforward. Just in the sentence, on average, 4 shows per month would cost up to 5 million. So there's, as Mr. Waters says, a space that must be between the 5 and the 0. That's all. It's 5 million, which totals 60 million per year.
260 million per year. Yes, Chair. Apologies for that.
Chairperson, if I read Mr. Molefe's document, then I believe he said it could be 1 million or more per show. Then he goes into the detail and speaks about the cost of an OB van, which is associated with one show.
Yes.
So if we then summarize it here, I think we should in fact summarize it as he has indicated. Because here I'm referring to his page 1, he says here the TNA breakfast shows came at a used cost to the SABC. The production cost could be up to 1 million or more per show. The cost for an outside broadcasting truck ranges from 250,000 to 500,000. Depending on the size of the broadcast and the facility being utilized. Most TNI shows use the big OB truck, which costs 500,000 per production. Now, I think we must just make sure that we can say that we can make reference to 500,000 per production and could be as much as 1 million per breakfast show. Otherwise, we actually only referring to the cost of the OB van. In my understanding.
Let me confuse your life a little bit further. You know, the document we're working on is on page 18. That's the document we're working on. Page 18 doesn't talk to rands and cents, other than on 1715. And yes, so 1713. And 1715. The document that Latapo was talking about and that Honorable Mahlangu was talking about was just their working document, which we tried to incorporate here. Now, if members are saying there's stuff here that needs to be incorporated on the basis of that input, we can always incorporate it. So I'm hoping members are following me, because our main document right now is on page 18 of our report. Are you with me, Ms. Killian? So if you feel that we didn't include the stuff that Latapo spoke about, you are free to add it onto page 18. Is that okay, honorable members? No, we're saying you're free to add it. We're not saying that you can't. We didn't add it. I mean, we never in our summary document talk about 5 million and all those type of things. But if you feel that it's important enough, we can find a way of putting it in. I'm just saying, let's look at page 18, and are you comfortable with what we've covered in page 18? If not, what must we add or what must we subtract on page 18 of our document? I'll come to you guys. I just want to are you following us? All right. Let's take Singh and take Waters.
Yeah, Chair, now if we just go to page 18, where you say technical equipment for one product could cost 1 million or more, right? 1 million or more can be 2 million. But I think that 1 million relates to what Mr. Molefe is saying is the production. He's then adding another 250 or 500,000 to each show. That's how 4 times 1.25 comes 5 million. So maybe 1 million or more will suffice, unless we want to say up to 1.25 million, if you add the OB truck. But 1 million or more, it's okay. But if we want to make it a bit more serious, we can make it 1.25.
Yeah. Chair, yeah, I mean, he does continue in that second paragraph in Mr. Malefi's submission now. No, I'm looking at Mr. Malefi's submission on my okay, sorry, not your document. And yeah, so all right, so we've got 3 going now. All right, that's why it's a bit confusing. He talks about the other costs, and that is, you know, the accommodation, flights, subsistence of the production staff, which runs up to another R500,000 if the show is far from Johannesburg, say Cape Town, Durban, or Kimberley. So he says if there's 4 shows per month, it could cost, and he says could. No, it's not exact science, right? Each show would have a different costing. He says up to R5 million a month, and therefore 60 million in a given year. And I think, given those figures, I think we need to put at least a 60 million in for an annual. I do. I think it's quite a staggering amount that the SABC is forking out, according to Mr. Malefi, and it should be stated in that paragraph 1713. That's my suggestion.
1713, you will see, honourable members, we try to, and again I'm saying we're open to criticism. After we speak about the 1 million, we say in addition, the SABC had to cover flights, accommodation and subsistence to its staff. Now, not Mr. Malefi or anybody has given us audited figures. But what we are recognizing is that there were costs incurred. Is that not the point? Because let me remind members that the debate was not about the rands and cents. The debate was, is there cost incurred to SABC? And that's what we're trying to prove. Were there costs incurred? Whether it's R1 or 1 million rand, should neither be here or there in terms of what we were trying to prove, in terms of the cost. That's what we were trying to do, because there's no ways that we could put a figure that we ourselves wouldn't be able to verify, other than to say, according to Mr. Malefi, indeed there were costs that were incurred. And we can substantiate it by his statement. Now, the technical aspects that members are putting in, whether it's 1 million, 15 million, 5 million, it doesn't detract from the point that he says there were costs incurred. I'm just appealing to members that, would that suffice? Yes, we're saying 1 million or more, and I'm saying, I don't know that we can put in any rand value, honourable members, because we don't have any audited figures, but let me take Loliwe. And again, what we are asking members is, we will go 1711, 1712, 1713 if we want to add or subtract from these matters. We now seem to be on 1713, and it's not a problem. We can start there and go back. But let's hear Loliwe's views on that one.
Thanks, Chair. Chair, on all the 1, 12, and 13, I'm comfortable. To me, I agree with you. Let us not stick to a price, a fixed amount, because should we dare do that, we'll be challenged and won't have supporting documents. But the 1 million or more is based on what we were told, and that is what we use to make our summary. Thanks, Chair.
We are on page 18. Is there anybody else on 1.3? What we are saying on 1.3, members, is that Malefi corroborates evidence that there were costs that were paid. Costs that include technical, includes accommodation, includes flights, includes subsistence, and it could be 1 million or more. Is there anything fundamentally wrong with that statement? No? Thank you. (711). Again, we're just talking about Mr. Malefi's input. Can we go back? Are you doing 711, Honourable? Yes, 17.1, Honourable Swartz.
Chair, this 17.11 states that Dr. Ngubane states that Mr. Malefi states that Dr. Ngubane had misled the committee. Well, he actually says Dr. Ngubane lied and deliberately misled. So I think we should insert that in inverted commas. States that Dr. Ngubane had, inverted commas, lied and deliberately misled, close inverted commas, the committee, because that's his actual words. And it's far more serious than just misled.
17, you got it, Cindy? Thank you. 1712. Basically denying that he was in agreement with that. I think that's clear enough. Is that fine? He says that he'd been against the takeover. Happiness? Yes. 1713 we've dealt with. 1714 of Phil Molife's evidence. That was the one that Letapo spoke about, that the trip to India was not linked to the Gupta family, and that trip was in fact for something else. That is what Mr. Molife is saying. Are you happy that we've captured that correctly? Thank you. '17 1714. Yes, let's take Matlangu and then Killian.
Chair, I'm just trying to think whether this information belongs here, where we've put it, or it should be 1714. Whether it actually must be here or should be in Gubane's evidence. Did we put it in the right place? But we are saying in his evidence, Dr. Ngubane. Okay, no, I think it's fine. I think it's fine. Then I think it's fine. Because it's a yes, and then okay, it's fine.
Yeah, Chairperson, it was just actually an explanation. If we just move to page 18, 19 at the top of the page, there's just a little typo, free to air, not 23-hour, but 24-hour service.
Right. Remember, we're trying to summarize evidence or inputs from members, not from members, from witnesses. If the summary is sufficient and accurate, whatever emanates from the input will be incorporated in our recommendations and observations. That's really the purpose of the exercise. Or if there's stuff that we have left out, like that raised by Honorable Swartz, then we must debate and put it in. And on that particular one, we'll put it in, Honorable Swartz. Anything else on 1714? Comfortable? Yes, sir?
We need to understand the purpose of this this document that has been presented to us is a summary of the actual submissions, right? So there's nothing, we're not amending this document at all, we're amending the original working document that we've got. So we don't, but we should be reading the main submissions. This is purely a summary that has been, and we need to pick up in the original submissions if there's something that's not in this document. That's the purpose. But it's not to amend this document, only to amend the original document that we're working from.
Let's reiterate. We've got evidence that was led, part one type of thing, which is just factual from the transcripts. We also then got to a point where we had observations or findings. We said to people, go and come back and comment on our observations, findings, and so on. They have now come back, and we've tried to summarize it. Otherwise, we would have to put 100 pages or more in our document. They've summarized it. We've tried to summarize the input. We are asking you if you're comfortable with how we have summarized the input, which will be a section in our document, and then we'll go to recommendations. So yes, this document, all we are asking you is to enrich this document, because you have also read the individual inputs. This is a concerted effort from the backroom staff. We're asking you to enrich this document, because this document, together with the observations, will lead to the recommendations. Are we clear on that one? Yes, sir.
And I fully agree with that, but the responses obviously go wider. And that's where because it's not only a response to the interim report, it's a response to the evidence that was led as well. And so we just need to bear that in mind.
Chauke and then Killian.
I just wanted to intervene on one point. We have been doing this exercise from the morning. I don't know what is different now, because we're supposed to just maintain the principle that we started with on how we deal with the information before us. Same as this document, we have dealt with it earlier in the same way. So if there's no issue that we want to raise, can we move to the next point rather than creating a discussion on something that is not there? If we don't have an issue around Molefe, we can move to another point. Thank you.
Honorable Killian.
Yes, Chairperson, I was under the impression that because you have now repeated the fact that this becomes a sort of a separate section, say Part E, and then the recommendations would become Part F. Now, because this goes into our report, we're just scrutinizing it for completeness and for accuracy. So this is the purpose, and therefore it is important for us to just correct wherever we have maybe missed out or something or misquoted anything, that we correct it. Because ultimately this will become part of our interim report. Thank you.
And just to reiterate, we'll come to you, Honorable Singh. To reiterate, when we get to the recommendations, honourable members, the recommendations will be based on the oral input, it will be based on the transcripts, if there are transcripts, it will be based on the entire 141 pages of the SABC, if we go through it. So anything and everything in there would be able to be the basis of our recommendations. What we were trying to do here was just when we give this document to Parliament, because they wouldn't have had the opportunity of looking at the 141 pages. When we submit this document, they should have a sense of what did Molefe say, what did TNA say, that's the intention of this document. Otherwise, we could write a very slim document and say to members of Parliament, go and look at 141 pages. That's the intention. I'm not sure where the confusion is coming in now after lunch. I'm not sure. Hey? Yes. Okay. But are we all right if we go in that fashion? Are we? Yes, ma'am.
Now forming part of the report.
Not the middle.
Chair,
The end, this one.
No, not that one.
Huh?
No, not the research unit.
But this one is.
Loliwe, it will be. Does everybody want to talk to this document? Let's take Loliwe, let's take Khosa, let's take Waters, and let's take Singh.
thanks, Chair. Chair, just like you, I don't know what is confusing us with the documents. The middle document, in my understanding, is a document that is lifting up the contradictions in terms of evidence that has been led, so that we understand why it is captured in the fashion it is in the document we are working on. So let us not be confused. Thanks, Chair.
Chair, I just wanted to know if the 50-50 revenue sharing arrangement that ought to have been there prior to Molefe do we consider it insignificant not to mention it in our summarized version? Because to me, it says something about what happened to that contract post-Molefe. I don't know if you get what I'm saying. Because obviously it also speaks to what Dr. Ngubane was saying when he disputed that there are any costs involved. If that 50-50, there would not have been that 50-50 arrangement if there were no cost involved, or if there was no revenue to be spoken of, if you know what I mean. So I'm not sure if our research team left that out deliberately, or maybe they thought it's insignificant. I just want to find out.
I think what Honourable Khosa is saying, if you look at the Molefe document around costs related to breakfast, he speaks specifically about including costs and specifically a 50-50 revenue sharing arrangement. That's what you're talking about, Dr. Khosa. And I think Dr. Khosa is saying somehow we must include it in the summary. Yeah, no, it's fine. All right. That's what Dr. Khosa is saying. You'll respond to that just now. No. Let's first take Mr. Waters. Because that is to enrich our document. Mr. Waters?
Chair, mine was a question of clarity on this document. Sorry. So, okay. I understand, yeah, our document, yeah, not the research document. I understand it's a summary of evidence given or submissions. This morning, we were told this is going to be an annexure to the report. Now, Honourable Killian mentioned it being part of the report. Just want to get clarity on that. She mentioned section D, or E, sorry. So is this going to be part of the report or an annexure to the report? That's all I'd like to know. Thank you.
Well, you must answer that question, honourable members, because that assists us. What we said this morning was that we would have put it as not an annexure, but we'll have, let's assume we've gone up to E in terms of observations. I don't know where we are now. Or let's talk specifics, because where's our report, Cindy? The report that we sent out on the 27th ends at Part D. Are members there? Ends at Part D. Our members are with us. So this would have been a Part E, and after Part E, we would come to our recommendations. Now, we either can put it in as Part E, or we can leave it out totally and use it for our recommendations. But our understanding was that this would be part of Part E to build up to our recommendations. That was our understanding, Honourable Waters. Is that okay? I don't want to open it up any further. We agreed on that one. Okay, it's fine. So let's go to Honourable Waters. That was the only question you were raising, sir. Okay. There was the question, honourable members, that do we put in the 50-50 revenue sharing as part of 17? Honourable Khoza thinks that we should put it in. It's important enough. We agree? You want to say something to that, sir?
Yes, Chair. I just wanted to note that in all the evidence that was provided, there is no clarity as to the gain that the SABC would, what the SABC would benefit from this agreement. Even when you look at the evidence submitted by Mr. Masinga of the proposed agreement between Apple Trading and the SABC, it does not mention as to what the SABC stands to benefit from this. They only mention that there was an agreement with regards to an editorial committee being established, and that TNA would then have 2 representatives on that editorial committee, but then does not mention who would be sort of the editor-in-chief of that editorial committee, as the Broadcasting Act would state that the group CEO is the is the editor-in-chief of the SABC.
Honourable members, let's look at Molife's input, the raw input, if you could call it that way. And I'm referring you, let me read the sentence, and I'm asking the question, do you want that sentence included? And that sentence says, this is Mr. Molife, I am aware that a business case for this contract was presented to the group executive, which set out the responsibilities of each of the parties, including costs and specifically a 50-50 revenue sharing arrangement. Dr. Khoza is arguing that we must put that sentence in. And that's directly from Mr. Molife's input. She feels that it will further enrich our document when we get to recommendation stages. Is there anybody that has a difficulty with putting that sentence in? Yes, Honourable Singh.
No difficulty, but I think we've got to add, because it's related, where Molife says, I would later learn that the contract signed between SABC and TNA under GCO that particularly excluded any reference to a revenue share agreement. I think that's important to add that, right, in following up on your 50-50. So it completes the story from his side, the picture from his side.
We're trying to reflect his story. Are we comfortable with that one? You followed it, Sunny? Yes. All right. So we will make reference to the 50-50, and then we'll go to say subsequently there was no reference. That's what you are asking us to put in, Mr. Singh. So it's fine. We'll add that to the Molife input because members feel that it's significant enough. And we will give you this report to make sure that we've captured what you've asked us to capture. So members must just make note of what you've asked us to capture today. Is there anything else on, we were dealing with 1714. Anything else on 1715 or 1714, otherwise let's move to 1715. 1714, otherwise 1715. Anything on 1715? No. Okay. So for the record then, we have considered and incorporated whatever we thought was significant from Mr. Molife's input into our document, and whatever else comes out of there will be reflected in our recommendations. Agreed? Can we go to the TNA breakfast? And then we'll ask you again, sir, to refer to your document if you have a page on your document. I'm just trying to get to our document page. Page 25 on our document. When I say our document, I'm talking about, for want of a better word, an extra E. Let's call it an extra E. I mean Part D. It's page 25 on Part D, and over to you, sir.
Thank you, Chair. On my document, it's pages 12 and 13. The submission from TNA was responding to clauses on page 28 and 32 in the draft report, which speak to TNA media. The first clause that they respond to is clause 6.3.3 in the draft report, which states that supply chain specialists were compromised and severely constrained because suppliers concluded contracts directly with the then COO, Mr. Motsoeneng. Mr. Nazim Hoa, a New Age Media Group representative, had instructed her, this is referring to Ms. Dlamini, to issue an appointment letter for the New Age newspaper subscription, but she would not cooperate. Now, in its response, TNA contends that the agreement between the SABC and TNA came as a result of negotiations which was led by Lucille Jacobs and Paul Nothen-Nagel, who were both representatives from TNA. They further contend that no one from their office gave an instruction to anyone at the SABC to agree to the proposal that was submitted by TNA for the subscription of TNA newspapers. The response further states that the proposal was put forward as a result of a request from inside the SABC that the New Age should be part of the newspaper bouquets that served at the SABC, but it's not clear as to who these insiders were who put forward the request. They then further respond to clause 7.2.1 in the draft report, which states that Mr. Masinga gave evidence about an unscheduled meeting with Mr. Hoa, representing the New Age Media Group, the parent company of ANN7, which had been convened by Mr. Motsoeneng. At the meeting, he was presented with a three-page bid to rebrand SABC News using SABC resources, including its reporters, while the New Age would retain the advertising revenue. Despite attempts to do so, the agreement was never signed. Now, in this section, TNA corroborated statements made by Mr. Masinga and other witnesses who were former employees of the SABC who stated that they had declined several proposals that were put forward by the TNA team. In the TNA submissions, TNA acknowledges that several proposals for cooperation were made to the SABC across a variety of areas, and that these proposals were put forward to various line messengers who subsequently declined the proposals. TNA further states that an exploratory discussion document was prepared to discuss the possibility of some news production being outsourced to TNA in order to narrow the urban-rural divide. Now, the exploratory document they are speaking to is the draft agreement between Applewood Trading and the SABC. And then they also respond to clause 7.2.2 in the draft report, which state that the committee heard conflicting evidence regarding the SABC's involvement in the TNA breakfast briefings. Mr. Molefe testified that Mr. Motsoeneng had initiated meetings with Mr. Tony Gupta in July 2011 to discuss a possible business agreement between the SABC and TNA Media Group. In the main, discussion centered around entering into an MOU in terms of the SABC, in terms of which the SABC would allow TNA to air live broadcast of its breakfast briefings on Morning Live, a huge subscription to the New Age for the New Age newspapers to be distributed in the SABC's national and provincial offices, for a stake in the SABC's news channel, which was still in the pipeline at the time. Mr. Molefe testified that he had not agreed to any of these proposals. In the TNA submission, they state that its executives started engaging the SABC in July 2011. The discussions were centered around the subscriptions and the business briefings. The submissions further argues that the business briefing project was launched without the SABC and that TNA managed the entire project using its own resources. TNA further submits that the entire cost of hosting the event, the business briefings, remains to be borne by TNA Media, except for the broadcast cost, which is covered by the SABC, which then corroborates a testimony by Mr. Mvoko and Mr. Mlefo, who stated that the SABC incurred heavy costs in the broadcasts of the business briefing. And these costs range from accommodation for production staff, studio time, and outside broadcast vans. Thank you, Chair.
Can we, having heard that and having read whatever you read, honourable members, from all the submissions, if we go to page 25 of our document, (2141) really is just an introduction. 2142. TNA is basically saying there, and that's what we're reflecting. TNA is saying that there was no instruction to do any business. This was a product of negotiations and the names that are there. And this is TNA's submission. We're not contesting whether it's right or wrong at this point. We're contesting whether it should be in our document or should not be in our document. This is what TNA said, and everybody said it. But let's take Mr. Waters and then Honourable thing. Let me warn, and on Waters, Khoza, and then Mahlangu, and Swartz, and don't be tempted to get into recommendations at this point. Just the accuracy of what we put here, and then Chauke will follow. Honourable Waters.
Chair, if you look at Annex A from TNA, I don't know if you've got it there. Annex A, yeah. When they were negotiating with the SABC, which they were, which proves it's a letter from Mrs. Jacobs, Deputy CEO. And she says the New Age is ideally placed to assist in the task of showing that the glass is half full, which is in inverted brackets. We have officers in each of the provinces focusing on reporting on your efforts. So this is trying to, in my words, entice the SABC to take out subscription, and they give the prices here and everything. I don't know if you've all seen it, eh? And I think that needs to be mentioned in the paragraph, that they use the word glass is half full to entice the SABC to actually subscribe to the New Age newspaper, because it's putting a positive spin on. Do you hear what I'm saying? It's psychological.
Okay.
You're giving a positive spin to news. The glass is half full all the time instead of half empty.
So,
and I would suggest that it goes into 2142.
42, yeah. After representatives. We can put that it was negotiations. That's what the suggestion is. Honourable Khoza?
I am covered. I was also worried about the non-capturing of that aspect.
You're suggesting that you and Honourable Waters are suggesting that after that full stop that says representatives, we add this portion. That's what both of you are saying, isn't it? All right. It was then. I think it was Mahlangu and then Chauke.
Chair, my concern is the old concern that I've been raising consistently. This is one document coming from a person who saw the report and responded. And we already have decided in a particular way on similar reports, and I don't know how we want to treat this one, whether we want to treat it differently. But my view would be we need to channel it somewhere instead of putting it here, because we are now reading something that has just landed on our plate.
Chairperson, I would like to somehow differ, because this affects a particular matter which we had very great difficulty to try and untangle and to understand. What was the essence of the arrangement? And here it is an affected party that is willing to provide the background, and it gives us a better picture. So in the case of another bystander, giving other additional information, this is just information that we've been dealing with, but we lacked certain sort of detail. And this is giving us a fuller picture of what and how it came about. My suggestion would be that we actually retain this, because they are mentioned. It's not like another individual or institution that is not mentioned in our report at all. So they are mentioned. They're giving us another perspective, and they're giving us further information. And then secondly, I would also like to just suggest that we, in our summary in 21.4.2, we include the period. That we just say Ms. Lucille Jacobs and Mr. Paul Noordnagel, that is in the third line, during 2011, because there were some negotiations, and if you look at the email trail, it gives you indication of when they started engaging with each other, etc. So I would like to ask Honorable Mahlangu that, unfortunately, this is one of those cases that you cannot be sort of very rigid in your approach. This is very definitely give us a fuller picture to understand what is the nature, and also to try and identify where we have contradictory evidence before the committee, what is more likely to be the position. Thank you, Chair.
Sir, on this matter?
No, not.
Okay. Yes, sir. And let's take Swartz, and we'll come back to you, Mahlangu.
No, Chair, this is important that we consider this, because there are allegations made against TNA, and therefore this submission that we've received is in response to those allegations in the interim report. So it is important that we consider that, and that we fully reflect in this report what their response was. Now, in that regard, it's interesting, if you look at their submission, that they refer to discussion around revenue sharing as well. But it was shelved as no agreement could be reached between the parties. So the challenge I've got now is there's so much in their submission. How do you decide what you put in and what you put out? In particular, that clause should be inserted, but then, in fairness to TNA, there are other aspects here. For example, there is a clause there that says, of great interest to the SABC was the content generated by the breakfasts, content that would be required in any event on the basis of the SABC's mandate. So when you are considering a submission, in all fairness, that clause should also come in. That is, we are reflecting here what they have said in their response. So you must, in fact, put in aspects which also confirm other views, such as in this case the SABC's view. So I would suggest that we insert both the TNA concerns discussions around revenue sharing, as well as there is a clause here, 21, and that would be 21.4.5. Of great interest to the SABC was the content generated by the breakfasts, content that would be required in any event on the basis of the SABC's mandate. That sentence comes from their submission, and that is paragraph 8 of their submission. Now, Chair, as a matter of principle, I'm not sure now, because as soon as you go down that route, how do you then decide when we deal with the lengthy further submissions? Because we are now basically capturing here very briefly aspects that we will be inserting into our response, into our final report. So it is a perilous path, but in all fairness, you have to reflect some of the aspects as well.
I'm not sure who you're expecting to respond to those questions.
Just saying
Because, no, I hear what you're saying now. It's not on you, yes.
Because when we get to the SABC's response, it's 140 pages or something. And we then have to fully reflect as much as possible their responses as well in this report.
All right. We're still trying to reach agreement on what we put in and what we don't put in on TNA. So I'm going to limit it just to that discussion on their entire input. Mr. Mahlangu, followed by Dr. Khoza. You want to speak as well? Okay. It's Khoza, Mahlangu, Waters, and Chauke.
Chair, I agree with my colleagues that they have raised important matters, but I'm arguing here on the basis of a principle. Now, if TNA were to put this document with the relevant authority, I wouldn't have a problem. But for us to accept this document without, indeed, whoever has sent it, why don't they then put it under oath so that we can treat it as such? Otherwise, because that's the only exception that I would personally say, okay, fine. If it's put under oath, then let's consider it. But just to take a document as it came in because we like the things that are here, because they're important, because it raised them, does not make it a justifiable, for us. It's going to create problems for us when we deal with other reports. We already have discarded others. I know the importance of the information, but let's then give it authority.
Chair, I was going to talk to what Honourable Swart said. The fact that while we are trying to keep the report concise and to summarize for people who are reading the report, there are going to be instances where we get a bigger report from the SABC, but we're going to have to elaborate a lot more than for other people. So we can't keep everyone at the same size or whatever. We're going to have to elaborate according to the submission that we received. So I don't think we should restrict ourselves there. And if a point is important enough, we should put it into the report. And then, Chair, if I may, did you say we have to talk about everything now? Or are we talking about this particular point about input?
To agree,
all right.
How do we deal with this input?
Right. So I would err on the side of caution where we maybe, if want of a better word, put too much information in and too little. That sort of be my suggestion. And I want to support Dr. Khoza and Steve and Honourable Swart with regards to what they've suggested goes into the report.
Yeah. No, I was going to follow the point that is raised by Honourable Mahlangu on the basis of a principled position that we have taken around how do we deal with fresh information and all of that. But maybe again, Chair, that the issues that we are dealing with, if we were to go back, they're not even based on any agreement between TNA and SABC, right? We have not picked up that information so far that there's a fundamental agreement between SABC and TNA on the issues that we are dealing with currently. So therefore, I'm going to propose that either we can extract whatever or note whatever information that we want, rather than just taking it correctly. The point that is making is that if we were to take this information as it is, then TNA can come and take a stand, and then they can then come and elaborate on the issues that they want to contest on or clarify on. For now, let us note it as part of the information that has came forward, and then we can extract 1 or 2 points that we want. I'm not saying just taking it down to the level of 1 or 2 points, but what is important in the report, we can just clarify and pick up on those issues rather than, taking it as a, fact that is being put forward before us, because it's not under oath, this report again.
Did you want to say something just before you respond so that you can help us? If members went to our document that we sent out, 1722, we are very emphatic. We say the committee heard evidence. conflicting evidence regarding SABC and the breakfast. Very emphatic in our report. And that report is very specifically saying SABC and it was on that basis that they responded, because this was a public document. Now, I hear all the sides of the story. I'm not taking one side or the other. I'm just trying to focus our minds, because there's a school of thought that says we should at least consider it in the body of our report. There's another school that says park it, but in your recommendations you can extract what came out of there. That's the debate I think that we're having. If we go on the one line, then we will take the recommendations that you guys are saying, let's include it. If we go the other line, then this debate is futile about what we should add and subtract. And I'm saying we must reach agreement on that one, because there's a school that says, the principal says we can't put it in the body of our report, and there's another school of thought that says it is so important and it was reflected on 1722, we should consider it. So that's really what we're trying to resolve, and there's no right or wrong answer, but we're trying to resolve. I'll take Khoza, I'll take Singh, and then I'll take Chauke.
Chair, first of all, let me say that my take on the mention of TNA and considering including what they are saying in the report, one, it is because, not because they actually came and gave the evidence, but they were implicated by the witnesses, and they speak to one of our key terms of reference, which is the financial sustainability. The issues that we are capturing here are beginning to speak to the issues of the quality of financial decisions that were taking place at SABC. And I therefore think that even if we can make the note that says in our summary of document that says, although TNA never came before the committee to give evidence, but they responded, but we need to include them because they are central to the contractual issues that are also getting into the financial sustainability of SABC, and that directly speaks to our terms of reference, Chair.
Chair, I feel the middle ground will be there's no harm in adding these two sentences that have been proposed, just to give our report a little more meat. Because in any event, I mean, from my side, and I think from the side of all of us, there is going to be a further investigation that we are going to recommend on this issue. Then all the facts and figures can emerge at that forensic investigation or whatever. But for now, I think there'll be no harm if we, just to complete the side of TNA as well, add these two sentences which were proposed by Honorable Swart and seconded by Honorable Khoza. Thank you.
No, Chair, I think it's, I will agree, therefore, with the colleagues, if we were to take it in that approach, that we then extract the two areas that you want to put into the report. The point that I was trying to raise again, Chair, on the basis of the work that we have done, that the question I was asking was that we have not received even the contractual agreement between TNA and SABC. So that when it comes to recommendation at some point, because we are going to make a recommendation here, I thought that we should maybe either, if that contractual agreement is not there, it means that this thing is just operating on autopilot. There's no agreement. TNA and SABC are just running as they run. So I was going to propose that maybe what we should do quietly, Chair, in the background, try and see if there is an agreement in place, signed agreement in place between TNA and what's called an SABC. When we do this agreement, with recommendation, we may want to reflect seriously deeper into this arrangement. I'm not sure if it is there. If it's not there, if it's there, Chair, I'll be happy to have sight of it, because I've never come across it so far since we have started the process. I may be out of order, but I think it's one area that I thought we should sort of have a side on, just to have a side that there is this agreement in place. Maybe during the observation we'll have missed it, but at some point, let me not even go to the point that we're trying to propose that certain people must appear on behalf of TNA, but let's leave it there. But let us try and get the contractual agreement, if it's there, in place. Aside from what you are currently doing, meaning that when we come to recommendation, Chair, I'm going to propose that we look at it very thorough.
Yeah, it's you need the wisdom of Solomon. I think Honourable Singh helped us out, honourable members. You see, I don't want to open that discussion. That's why I'm saying you need the wisdom of Solomon. But I think we can confidently say here that we're all going to agree that there's going to be a recommendation that says look into certain contracts. We can say that confidently. So we shouldn't be exhausting it here, other than saying that in fact, if you don't, let me sponsor that recommendation. That says, at some point, there will be this type of thing. I mean, if we all agree that this is something that is going to be work for either the board or somebody else, shouldn't it suffice for us to say we're just noting it and those that take it forward will consider all these matters? That's the proposal that I'm saying so that we can move forward. But let's listen to Chauke.
No, Chair, it did not need Solomon's wisdom. It needed that exactly proposal that you are making, that maybe what we should do, we pack it. When we come to recommendations, we can then come with that Solomon idea, which will be wiser to be able to move forward.
All right.
What baby are we cutting in half now? But Chair, no, for the sake of Cindy, so that you don't fight with us tomorrow, we're going to add that 50-50 revenue plus the additional that somebody added. Is that what you want to talk to? Yeah, that's what I'm trying to say. So it's for the sake of this report. Somebody said there were two issues that we must put. The one was that 50-50 revenue. What was the other one? Have you the other one was that the last where they say it was the content. About the content.
Correct.
And it's their paragraph 8.
Correct. Yeah, okay. So we're happy that it'll be those two. We will take them out of the document, put them in there for balance purposes. Baba?
Two things. The first one is, are we putting in the glasses half full? Did we agree to that? Thank you. Then just on the 50-50, Chair, sorry. Okay.
Hold on. We had agreed earlier that
Yes,
the glass
we
was...
had.
You've kept
Just
it,
confirming.
Yes. And Ms. Hold on, just before you carry on. Glass is half full. Mrs. Killian's 2011. The content and the 50-50 revenue is all that we've agreed upon so far. So we don't want members to talk to those things anymore. Yes, sir?
Chair, I'm talking to Annexure C, which deals with the revenue split. Sorry, and I don't want to contradict anyone, but if you look at the email from Mr. Hienis to Nazim on the 14th of November 2011, he talks about a 40-60 split in favor of the SABC, right? Then the following day, Mr. Nazim replies to Mr. Hienis, and that's at 7:35 in the morning on the 15th of November, and he suggests a 70-30 split in favor of the SABC. So I don't know if you guys are with me. Do you see that, right? Okay. So when we're talking about the 50-50 or the 60-40 or the 30-70, I think we need to clarify that there's contradictory evidence here. We actually don't know what the split actually ended up as, do we? Because we haven't seen the contract, as Honourable Shaki has said, if there is a contract. But the fact of the matter is, I think we need to emphasize the what was said in these emails. Annexure C.
Mr. Waters, are you done?
Sorry to confuse the matter.
No, it's fine. No, we can do this because we must own this document at the end of the day. But I thought those points that you were raising were all part of negotiations. I mean, you start 50-50, you go 70-30, you go 20-20, and that's why we're saying at the end of the day, investigate this contract. That's what I thought. Yes, sir.
Was my wording. The wording is we're reflecting what TNA says. TNA confirms that discussions around revenue sharing were discussed but shelved as no agreement could be reached. So that summarizes all that discussion. Now, I don't know about the 50-50 that was spoken about, where that insertion comes in at the beginning.
Yeah, right in the beginning.
But comes in elsewhere. So, but this is purely reflecting what TNA says in their submission. That's all.
Under Molefe's submission. It's a different one altogether.
Yeah, Chair, I wanted to say it actually speaks to the fact that there was at some stage some consideration on some sharing of the revenue, and TNA is actually confirming it. And this is important because as far as Ngubane is concerned, there was no such a thing.
All right. Yes, sir?
50 was actually under Mr. Molefe, not under TNA. Yeah. He said that. Yeah, and then these emails suggest something else. So so it needs investigating. No, I agree with you. Yeah, I agree. Don't worry.
Okay. For purposes of recording in our document, the 50-50 we agreed will be under the Molefe input. We've agreed on that one. Around this input are the issues that have been raised now by members that talk to the content.
Paragraph
the half full.
It's paragraph C and paragraph 8, and then the half full.
Yes, and the half full and the 2011 in terms of the specifics that was raised by Honorable Killian. Yes, sir.
Chair, while Honorable Chowke referred earlier on to a contract, and I agree we haven't seen a contract, but what we have in our documentation here is the SABC confirming an in-principle commercial business partnership between the New Age and themselves on the business briefings. And that's the last document here where they confirm a 40, I mean, the SABC didn't want 70, I don't know why, and give them 30, but they agreed on a 40-60 split in favor of the SABC. Now, if I'm a businessman, I'll want more for myself. I would have taken the 70, but they were prepared to take the 60. So I think we've got to note that somewhere, that there is correspondence here which suggests that the SABC, represented by Anton Yunus, confirmed that they will engage, will in principle have this partnership with the 40-60 split. The last Annex C, the second part of the...
So you're suggesting we must add, remember we've added 4, we must add 5.
This one.
5 points.
Where the SABC confirmed this partnership agreement.
Where the SABC confirms it. I have consulted my principals. Just read, which one is that? Is that one?
It says, Dear Nazim, Monday, 14th November,
no, hold on.
1802.
Oh, okay.
I refer to our previous discussions and more specifically to the meeting of this morning. This serves to confirm an in-principle commercial business partnership between the New Age and SABC on the business briefings venture. And then they go on to say everything else. They talk about the revenue share model. The SABC is of the opinion that a 40-60 split in favor of the SABC is equitable. And then they talk about other things.
So you're suggesting we put in that sentence, this serves to confirm. Just that sentence. Just that sentence. Okay. Trying to go forward so that we don't go over underground. We've now got 5. We've got now 5 more submissions on that one. Yes, sir.
No, Chair, I'm saying that there is totally nothing wrong that in the process of dealing with the submissions, that if we pick up that there's a need for us to do some kind of a follow-up on something outside which help us. In fact, if submission help us to do a follow-up on certain information that we may require as we prepare for the recommendations, I think we must be flexible to do that part, Chair, without really opening up a can of worms for everything to come back. But I think it's important so that by the time you get to the recommendation side, you have had an opportunity to look at evidence before us, but balance it again with contractual arrangement if there's any. So that when you make a recommendation, it's not only informed by what we have received, but back it up by information, meaning that if there's anything signed between the two players at a particular point in time. I thought it's very important, that point. I'm not saying that we must go there now, but I thought that we must be flexible rather than just losing ourselves into a process.
Yeah, no, that's fine. We can do that. Let me again go back to the point that I made earlier this morning. Recommendations are our responsibility. It's our responsibility as members. So if Vincent sponsors a recommendation The onus is on Vincent to say, I'm making this recommendation and there is why I'm making it, and to convince you guys that it must be bought. I'm hoping we're not thinking that the backroom staff are going to go for all contracts and those type of things, because they couldn't know what our recommendations are going to be at this point. It's impossible for them to know. I hope members are with us on that one. So when I make a recommendation, I should be able to say this is why we think that recommendation should be there. But if you ask the staff to go and get every contract that's available, when I say the staff, I'm talking about us in the back room, it's just not going to be possible, members. I want to move on the TNA. Is that still TNA one? Yes, yes, sir.
Very briefly, Chair. Now, this, you see, the SABC deals with this contract in depth, and they allude on page 115 that the contract was signed. So we'll deal with that when we get there as well. But there is a contract that apparently was signed. We don't have to get it, but there is a version from the SABC that on this issue as well. But we are only recording here what TNA has said. That's the key thing. Yeah. Okay.
I keep on going back to that point, honourable members, that you must be comfortable with what we've captured on page 18, or whatever the page might be, is a fair reflection. If it's not, you add as you have rightly suggested we add. If we must subtract, is as you've rightly said we must subtract. Going to our input on TNA, which is on page 13, our understanding from where we are is that we're going to add 5 more points. No? No? Is this the research report? Oh, no, this is the research one. I beg your pardon. You're right. On page 25/26. Yes. On page 25/page 26 on our report. This part D or whatever the case might be. We're happy with 2141. We're happy with 2142 as I understand it. 2143, 2144, and then we'll add these other matters that members have now raised. Is that our understanding? Mr. Singh.
Safe, Chair. I think I need to withdraw the last aspect. You know, where this serves to confirm, because that is not what TNA said. It's what the SABC said. So let's leave it out of this section where we refer to TNA. Am I clear on that one? Right?
Cindy is saying TNA provides the nexus. We can put it on both sides. It doesn't matter, because I mean, right. she's saying that TNA. We're working with the TNA's
okay, right.
input.
Okay, fine.
So I don't think you're very wrong on that point, sir. I think we can live with it. Are we happy with the TNA's input as it stands? So we'll elaborate it to include those 4 or 5, and Cindy has captured them. And of course, on the basis of that, it will either affect or not affect our observations and recommendations going forward. Anything else on TNA's input that members want to consider? Going once? Done. It is 4 o'clock. Do you want to take a 5 minutes break? Then we've got Dr. Ngubane, the Minister, and SABC. And I'm hoping that if we do justice, we can even complete all these tonight and spend 3 days on recommendations, because that's where everybody wants to get to. So it's 4 o'clock now. If we want to go the whole hog, then we can have a 15-minute break so that when we come back, we have enough strength to at least do, I can tell you the next 2 are going to be as lengthy as this one is. So maybe saying 5 minutes to what you were saying, Mr. Singh, pushing ourselves for pushing sake might not do justice. If you so wish, honourable members, we could come back at 4:30 and then see how far we go up to whatever time and deal with the rest. Is that okay with members? Yeah. Is that okay? Once again, we will make sure that this place is secured. Eh? Coffee. Oh, it'll be here, eh? All right. So we don't have to secure the venue. Yeah, all right. Honourable members, it's then Dr. Ben Ngubane, Minister, and the SABC. Those are the last 3 submissions that we have before we move on to altering our observations and going on to recommendations. We will break until 4:30. When we come back at 4:30, we will tackle those and see how far we go today. And then we have the MOI that we definitely will do tomorrow. Is that okay? That's okay, members? 4:30 we reconvene. Thank you, members.